Okay, so this is David Randolph Kelly. This is more of the court audio from, this is actually March 5th, 2015. This is going to be the closing argument of my attorney, Mr. Gunn. And honestly, he does a summary that is, better than I can do. And it just walks right through everything very well. So anybody that wants that, I can give the case number later. But I'm going to go ahead and just play. It's a little bit lengthy. Here we go.
Closing argument.
John Mark Twain, I also like Thomas Jefferson, so I'm going to read Thomas Jefferson quote. I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution. Thomas Jefferson. Ladies and gentlemen, that is a true statement. The state closed their first closing argument by telling you that if my client caused the injuries, he is guilty of the charges. Ladies and gentlemen, that simply is not true. This is why. The judge is going to give you instructions, and he will instruct you as the law, and one of them will say defense, physical force, justification, parent. I want to read you that instruction. And then ask yourself, is that really what the law says? Or is that what the state wants you to believe the law says? And then I want you to listen to the judge when he reads the law, and he will tell you what the law says. But this instruction reads this. Oregon law provides that use of physical force on another person that would otherwise constitute an offense is justifiable and not criminal under the following circumstance. A parent, guardian, or other person entrusted with the care and supervision of a minor may use reasonable physical force on the minor and to the extent, listen carefully, that the person reasonably believes is necessary to maintain discipline or to promote the welfare of the minor. The standard that you will read in the jury instruction isn't whether Mr. Teamleaf or the judge or I reasonably believe that what was done in the situation was necessary to promote it, but whether Mr. Kelly reasonably believed that what he was doing was necessary and appropriate to maintain discipline and to correct behavior. That, ladies and gentlemen, is the law. Remember when we started this proceeding, we talked about how do we discipline. Some said, I think spanking a teenager may be appropriate. Some said, I never had to do that with my children. Some said, yeah, maybe occasionally when they were younger. You see, we have a community standard, but the legal standard is what does this man believe? What did he believe was reasonably necessary? That's what that instruction says. We don't get to put our own biases and prejudices and feelings and put them on Mr. Kelly and say, well, gee, I would have done it differently, and therefore, because I would have done something differently, he must be guilty. That isn't how it works, and that's difficult. We have to separate ourselves and try and be that impartial fact finder. To look at him and his situation with what he was dealing with, and then try and determine, was this man using reasonable discipline when this happened? Now, what are some things we need to look at deciding whether or not that defense applies? Because remember, the defendant isn't required to prove anything. The state must prove to you beyond a reasonable doubt that that defense that is here and that I've just explained does not apply. So my client doesn't have to prove that, but he took the option to take the stand and testify to you as truthfully as he could about why he did what he did. So what was he dealing with? He was dealing with a young man who was entering puberty, 13 or 14. A young man who is now becoming the oldest child in the home and is having some problems. These aren't maybe just the typical traditional problems that all our kids have. Some of them got pretty serious. We've heard testimony that this young man had threatened to kill another student at school. Parents have been called in to deal with that. Police officers have been involved. We've heard testimony that this young man was making threats against his younger brother, was getting his younger brother to engage in destructive behavior, his 7- and 8-year-old brother to engage in these behaviors. We have him being willful and disobedient at home, not doing his chores. We have letters that say what was going through his mind. These are not safe, normal things. These are behaviors that Mr. Kelly felt, as he testified, needed to be corrected. He had a reasonable belief that correcting these behaviors was necessary, not only to maintain discipline in his home, but to promote the welfare of his son. So, what does he do? What do they both do? What does the mother do? They started with, he had a problem with the computer. You've heard about that. So they took away computer privileges. That worked for a little while, but not for very long. So they took away other privileges. They added chores. You gotta go do your chores. You know, gotta clean up the dog poop in the backyard. I do it with a spoon. Oh man, really? Did you believe that? The only one that says it with a spoon is a young man who's already admitted lie. The only one in this courtroom who's an admitted liar. Now, this counsel's correct. It's good that he's come here today, and it's good that he's in a better place. And that today he'll say, yeah, I lied. But I want you to remember, this whole thing started with a lie. Who called the neighbor? Who called the police? It was the neighbor. What had the neighbor seen? He'd seen a cut on the eye. A cut that was caused by the concrete incident. Okay, you've got a picture of it. You saw that. That's a true fact, right? There's a picture that shows that was there. But what was the rest of it? Why else did he call the police? Because he had been given the contents of Exhibit 120. And the judge will send you back with these exhibits. You'll get this whole book and you go through it, and I encourage you to go through them because these exhibits help tell the story. He was given 11 pages of lies. One lie after another lie after another lie. As you sat here, and we're not to weigh how long a witness was on the stand otherwise, but the first, I don't look at your notes, 45 minutes of the testimony given by Dakota was saying, I lied, I lied, I lied. That wasn't true. Yeah, I lied about that. No, my father didn't beat me. No, he didn't drug me. No, he didn't do this. No, he didn't do that. No, he didn't do that. No, he didn't do that. All lies. But that's what started this whole case, right? Was the lie. And here we come, and now you are starting your case with the lies. The state started their case with the lies. So what do we have then? If it starts with a lie, then how do we decide what the truth is? Let me submit to you that there are a number of things here that we know aren't lies. At least they're not biased. They may be biased by the people who took the pictures, but we have pictures. And I'm going to go through these briefly because I think these are really important. And I want you to look at them, and I want you to compare the pictures. There's a reason why I spent so much time on the photos, because I think they tell the story. One of the injuries complained about was abrasion in the forehead. I want you to look at picture 109. See this abrasion here on the side of the head? Is that an abrasion, or is that a young man that's got a little bit of acne and he's picking up? Okay? That was taken by the police officer. Let's compare that picture to the picture of the head injury. What if it is, in theory, picture 112, or exhibit 112? Forehead injury. See the different mark? There's the head injury. Right? Doesn't that in fact look the same? He's picked on a scab. How about that? This is the head injury from when he hit his head on the floor. Or so that's what you were told. But isn't Isn't that in fact the young man that's kind of been picking himself? Isn't that really what that is? Okay? And you're in his left arm. And here's a picture of his left arm. Now I want you to look at this. Remember, pictures show what's there to be seen, but I think we all agree the photographer makes a huge difference. What you see here, but what don't you see here? A man's left arm. Young man's left arm. What do you not see in that picture? You don't see the self-inflicted injury, do you? The officer, and I submit to you, is taking a picture in such a way that does not in fact reflect this injury. And why not? Why not? Because he wasn't told that this was inflicted by the thing. He was told by that young man that the one in his shoulder was. So he didn't take a picture of this injury. No police officer picture of that. Bumps to the back of the head. Okay. Seems to be a hotly debated topic. This is the picture taken by the officer. Not super clear, even though he could have looked at it and made it better. We'll figure that's the best he could do. These are theoretically the bumps on the back of the head. Or so the state tells me. What did you see? You had a number of witnesses that say, he's got a misshapen head. His mom called it a birth defect. We know what it was. His mother told you what caused it. She was working a lot when he was young. She's trying to support herself, left him in the car seat too much. I think she feels pretty bad about that. She, a little emotional when she said, yeah, that. Mother's explanation as to what that was, and a little bit of guilt as to why it was caused. His brother told you that he felt him shave his head before and had to watch out for that because a little raise there in the back of his head. And you see it today, that's for you to decide. You decide. You didn't get to see him from the angle close up, did you? It's come straight from the back of the head, so why don't we look? Another picture taken 5 days before. Let's look at this. Look at the back of his head. Okay? Again, this is a picture taken by mom, trying to show the writing he made on his back. So made his little brother write on his back. His little brother didn't want to do. Remember, I was engaged in them, the problem, but here's him. Why? And you'll get to look at these closely in mental health, but I want you to look at this. See this area here? Where the hair goes around a bump on the back of his head. You know what that is? Isn't that where it's been shaved so tight, but yet this area here isn't quite as close because it's on the opposite side of the bump of the head? The bump of the head that supposedly was caused by being pulled out of the bed, but was there 5 days before. And finally, the chokehold. You'd all agree that choking a child probably isn't discipline. So let's look at the chokehold, right? Some evidence of that. The only bruising. Remember, there's no bruising around the head. The officer doesn't testify any bruising on his backside. The young man was spanked 40 or 50 times, according to his own testimony, apparently by an angry father who, much bigger than him, he's spanking him 40 and 50 times. Where are the bruises on his rear end? Use your common sense and reason, folks. If you were to get spanked 40, 50 times, wouldn't it leave a little bit of a mark? Zero evidence of that. Why? It simply didn't happen. But there is some bruising. There is some bruising. The officer said, yeah, I took pictures of it. Here we go. Here's the jawline. Here's There's the bruising. Not a very good quality picture. Won't necessarily fault the officer for it, but you see it here? It's his right jaw, right along here. This is the evidence of the chokehold. Or so the state tells you. So 103. 5 days earlier. Right there. Right there. Look at the right jawline. Look right there where the picture that the close-up shows. Pictures don't lie. Young men who want to see their girlfriend because they're being punished for inappropriate behavior do. Ladies and gentlemen of the jury, these injuries were not injuries caused by this man. It simply is not true. It simply is not true. This father was trying to correct inappropriate behavior in a young man. He couldn't get help from the police. He couldn't get help from the DHA's caseworker. He couldn't get help from the hospital. He couldn't get help from the mental health facility. He could not get help from anybody, and what did he do? He did the best he could. They had taken away the privileges. They had given additional chores. They had confined him to his bedroom. They had taken away his privileges with friends. He'd done everything he could do, and on that night, when he has now instigated his younger brother into the cutting rituals and the dangerous and inappropriate behavior, on that night, after he has gone through months and possibly years of this, he says, I don't know what I'm going to do. I'm going to go in and give the kid a spanking. He freely admits, yeah, I didn't go into that room to talk to him. I went in there to give him a spanking. Because all this other stuff hasn't worked. I went in to provide reasonable discipline. The person reasonably believes is necessary. He did what he reasonably believed was necessary. And despite what the state said, that he was going to do it until it hurt, is that what my client said? Or did my client say, I'm going to do it until he felt it? Isn't there a difference? Was he trying to hurt his son? Or was he trying to discipline his son? The beautiful thing about being a juror is you can disregard everything I say. You can disregard everything Mr. Tingley says. Because that's not evidence. You heard the evidence. You'll see the evidence. And in the end, I ask you, isn't it true, truly, has the state convinced you beyond a reasonable doubt? Have they convinced you to a moral certainty that this defense doesn't apply? Are you convinced? I'm going to ask you to find my client not guilty. Thank you for your time and your patience. And now, after the judge's instruction, the burden shifts. For me to represent my client, to you to render a true and fair verdict.
Thank you, counsel. Mr. King.
All right, and from there they go on into jury deliberation later on, where the jury fully acquitted me of all three charges, which were pretty serious. They were assault for criminal mistreatment of a minor and strangulation. And they all started off, as my attorney said, with lies. And, it's unfortunate, but I guess if somebody really hates you enough and they make up enough crap and they repeat it often enough, some moron is going to believe it. And in this case, it's the morons that are the police department for the city of Salem and the morons that are the DAs that represent this area and evidently the state of Oregon, because they're pretty fucking stupid too. So, anyway, that's my opinion. And I'm entitled to it after having gone through all this stress and about $30,000 in costs. Bottom line is, though, I was found not guilty. I tried bringing information to the police department after the fact. I got a big runaround. I was threatened with harassment for trying to bring court audio and further pictures that they didn't have to light, as well as we had another witness, evidently, that sat with us, stayed with us, was in our house, and never said a doggone thing until after the fact. And the kid admitted that to his cousin that he'd made the whole thing up because he was angry and what have you. And so, point being, I don't know if this is going to help me or not, and I don't know if it's going to help our family, but hopefully it will, show people what can be done to you, and that these people that are supposed to represent you are fully willing to accept lies, promote lies, punish you on lies, and do not ever, 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 ever take a bench trial. Never take a jury trial, because otherwise that judge would have put my butt in prison, and that's where I would be. So, rely on your neighbors and their good judgment, and protect yourself. If you're having problems with kids, protect yourself with photographs and documentation of every kind that you can make, and that's the only thing that kept me out of prison, as well as having a lawyer that was privately paid for, and that was a good quality, that was a trial lawyer. Understand that these